Hello, ladies and gentlemen. We are back with the IP Business Talks. Today we have a topic. We want to talk about this interrelation between knowledge of an industry, knowledge of firms, how firms act with IP, how they manage IP, how they make their business. And on the other side, being an external IP counsel and consultant, lawyer, attorney, and standing in front of the company, so not being really a part of it. So how important is this industry knowledge for patent attorneys? This is a live show, so for all the audience who are regularly with us, they know that we are happy when you write us comments in the chat. I will pick them up and will talk with them with my guest. So, and I'm very happy to have Bernd Bösherz with me today. Bernd, hi, good to have you here.
Hello.
My first question to you is a question which I ask every of my guests, because no young boy wakes up in the morning and says, "Hey, I want to become a patent attorney." So typically there is a certain development and evolution to come into that field of practice. Bernd, what was your reasoning? What was your way to come into that strange field of intellectual property?
Yeah, thank you, Alex. Indeed, actually, I was not born as a patent attorney. Actually, I did my studies in electrical engineering and started a normal industry career as an engineer. And the funny thing is that during that period, where I actually mainly worked in managing roles or management roles, very late in my industry career, actually the question came up in our company. They were looking for a person that is from internal, that is able to discuss, who knows the internals of the company and everything, and he would like to do this role, and also is maybe let's say a kind of interested in doing a lot of paperwork as well, because patent work usually is quite paper orientated, or it was quite paper orientated. So that was quite late, and even from my age, I was actually I was over 50 when I started my patent career, and before that I was just working as an engineer in management roles in an international company, in a national firm.
Mm-hmm, mm-hmm. Yeah, so from LinkedIn, we know that's Vodafone, right?
Yeah, that's right. It was basically the telecommunications industry.
Yeah.
Where I had a lot of fun, and started quite early in 93, when actually all the mobile network business started, where actually telephones were as big as little laptops, and today, they are much smaller and are smartphones, and at that time everything was quite different. And my main task at that time was basically at the beginning is specifying specific network elements, or like base stations, to specify the requirements, for the network suppliers, that are providing.
I would assume that you mean 2003 and not 1903.
Oh, I'm sorry. Yeah, it is actually, I started in 1993. Yeah,
1993. Okay.
Perfect, because I'm not that old. Yeah, you're actually you were the record. Yeah.
Yeah,
sorry about that.
We discussed that earlier, and there we found a very interesting paper which I published on our IP management letter. So, by the way, to the audience, that is a new blog which is available on my website, and we published there interesting research nuggets, a paper which are important for IP management. And one of them is this here that comes from Finland. And it is about the evolving role of patent attorneys in a management in a knowledge economy, and in a more and more managing role for the companies. And so that is a very good. It is quite news from 2023, and it shows how over the last 30 years there were so many institutional transition, technological changes. I mean, Bernd, you come from the telecom industry. I mean, in 1993 compared to 2003, 2013, and 2023, we see more or less completely different industries. So we can say, saying I have industry experience means in that different decades something completely different. So that is also a very dynamic environment, right?
Absolutely. You're right, and it usually depends a little bit on the career path an engineer before he maybe becomes a patent attorney. The career path is actually quite unique for every patent attorney. And one is working in R&D only, and has a very technical depth insight, so to say. And from my perspective, actually, my career was quite unique as well, because I was not only working in the technological area as an engineer, I was also working in the supply chain area, learning quite a lot about the supply chain of an international firm like Vodafone, and there was a lot of process development we had to do, and to think about common supply chain strategies as well. And in that role, basically, where I was leading an international team, we mainly were cross-functional, and were thinking about how could we valuably integrate R&D knowledge into supply chain strategy, because it's quite interesting to see, okay, today we buy these products that we are using today, but what about tomorrow? How do we have to apply or adapt the strategy, because we are developing new technologies or new services? So that was quite interesting. And also today, with my work as a patent attorney, it gives me a lot of understanding when I discuss with the, let's say, R&D technician, the inventor, or with his IP manager, or with somebody from the executive level.
So my experience is that one really major difference, depending whether you are in a company or whether you are a patent attorney, is the question what means success. So when you are in a company, you have typically very complex success measures or objectives. So things are extremely complex because they are interdependent on each other. You have politics in the in-house. You fulfill typically, or you have to work in different lines of strategy for different departments, whatever. So the world is extremely complex, and what means success is a very difficult measure. On the other side, this is extremely difficult to understand for a patent attorney who sits outside and has all that information. So simply to agree on a common understanding what success means, for example, in case of an innovation, not just one patent, of an innovation, that seems to me a very challenging issue, and maybe something which makes really the difference between somebody who has the experience in-house or somebody who has never worked as an in-house counsel or in an IP department.
Absolutely. Actually, it is, you ask as a patent attorney with the industrial experience, you may ask completely different questions than just the usual legal questions you ask when you are thinking about an innovation or invention, something which is new. What about the competitors? Are they developing maybe a similar project? But basically, to understand how this company or this firm is working, how the process is internally organized, what are milestones where they have to decide how to go further in their business development or on their roadmap. You can actually ask questions that are not at all on a legal basis. You just talk business with them because you understand a lot from your own experience how these processes could work. The financial background, the budget planning you need to do, the milestones maybe they have, if they have a process like that, an innovation process. A lot of companies they don't have that, and basically that was something I was sometimes using.
They have one, but they are not aware about it, or it's not documented.
Yeah, mostly it's not documented. Mostly it's really not documented. That's right.
Yeah. So some patent attorneys tell me that it is, and for a long time I've worked as a consultant, so I can confirm that very well, that it is sometimes very tricky to interact with companies because even when it is obvious that it makes absolutely sense to understand the internal perspectives, the branch, the competition. One of your colleagues, Maya Fenster from Israel, we had a wonderful discussion last year exactly about that. So what do we have to know about competition in business? And yes, this is extremely important. But these patent attorneys tell me that there is a kind of Chinese wall with some companies and or representatives of the company, and they just don't want to share that kind of information with a patent attorney. So they reduce intentionally, so you can say it's rational ignorance, they reduce the interface to the invention disclosure and that they want a patent. So do you have also that kind of experience, and how can we tackle that?
Yeah, actually, yes. I had this experience actually a few times, and also in my industrial experience, actually working internal because at the end of my industrial career, so to say, I was working in the patent department, in the internal patent department as an IP manager. And even there, sometimes, you do not get or do not receive all the information necessary sometimes from the guys who especially about their business strategy or the business objective, or how do they want to launch the product, these kind of things. And I agree, sometimes you have these Chinese walls, and having the industrial experience and the experience basically that I also gained in the managing roles, then you understand, okay, who are stakeholders, and then for that perspective, if there is a wall, you have to find a way around it or over it. So from my perspective, what is important is actually for a patent law firm or a law firm in general, it is to have different communication channels where you are able to receive information. So let's say the patent engineer with a good technical understanding, discussing with the inventor, that is one level. But you also need, on a partner level, mostly, you need the communication to the CEO or the CTO of a firm. And that is something, when you have industrial experience and you were working also in managing roles, then you know how to create such a connection where actually then you can approach such a person, and even actually this person gives you information, or they initiate that you receive the information on the
they understand level. The need.
Yes, exactly. And that is very important, and something that actually I always, when we discuss with our clients, we always have this multi-level communication channel concept in mind, and we try to establish actually these kind of communication channels with the let's say with the persons in the company. Yeah.
It
So
is totally funny that you tell me that, because I'm absolutely convinced that this is a key issue, and I would boil it down to the fact you have to be interested in your client, and that is really something. When I make these LinkedIn trainings for IP experts, right?
mhm.
And then we discuss, yeah, why is LinkedIn important? Blah blah blah. Yeah, this is just about vanity, and I know what, and I'm not interested in that. It's like, hey, look, your clients are there, okay, and they post there, they discuss there. So when you give comments, when you can write there your perspective on these issues, they see that you are interested in their company. Yeah. And then I hear, yes, I post there. I say, yeah, to make your homework. I mean, that means you are able to interact with them, and not just to reduce the whole problem to an invention disclosure and a patent filing. And and today, social media, LinkedIn gives us really that chance, that opportunity. And sometimes really they stare at me as that when I say something which is completely out of range. Yeah. So what you say is exactly that this is a way to get that information, to show the interest, and also to make a stronger binding between the patent attorney and the company.
Absolutely, and maybe just one little thing to add, but this little thing is important. Even the career you have made, so your career path in the industry, if that is transparent to your client, yeah, especially to those in manager roles, IP manager or executive level, that also opens the communication, because they more and more, due to the conversation and the discussion you have with them, they open and they give you much more valuable information. Because what I always try to make transparent is that we need to understand how the business is ticking. Yeah, if we understand the ticking, then actually let's say the result of a patent application can be different, because we
Absolutely.
know we have much more. It is not just looking at the novel features and then do our hand working, yeah, and then we have a fine patent application with all these backgrounds. And it's not always around drafting, it's about, how do we enforce maybe patents, or how do we defend ourselves or the firm, yeah. And I always try to bring or to discuss with the client, actually, to make him aware that we are partners on the same level. That's something I would like to arrive. We support them in their business success. We succeed as well when they have success. That as simple as that. And that's something which is very important from my side to formulate that. And with the background of the industry you have, and also the ability to be able to communicate to a CEO, it's a difference if you talk to an inventor, or if you have to talk to a CEO who actually always looks on his watch, or is looking on his watch. His time is very valuable, so you have to be very precise in your argumentation and on point, yeah. And because he will not discuss with you for an hour, yeah.
Yeah,
That's
absolutely. Absolutely. You have to go to the point and have to speak their language. I'm so much in favor of what you're saying. That's my whole experience. And it's interaction, it's communication. It's not just, so people tend to say it's people business, but it is basically, it's a communication business. And that means interest in the other, interest in what they say, and how you said what means success. That's exactly the point. So to be open, to understand, the success understanding, the success perspective of the other. So it doesn't help when you define for yourself what success means, by the way, or what quality means, when you have not the buy-in of your client from the industry. There was a wonderful podcast from Felicitas Banzhaf and Bastian Best. The podcast, the name, I just checked it because I forgot it, is Datenfluss und Drehmoment. And so Felicitas is a machine engineering patent attorney, and Bastian is a computer scientist, and they discussed about the difference, and that was absolutely fascinating. So each and every episode I fall in love. Great. And unfortunately both realized how much work it is, and they did not continue with that, but each and every episode which is available is brilliant. And Felicitas Banzhaf, she's the machine engineering part of that discussion, and she came up with an example and said, once there was an invention, and they came to her, and it was a classical mechanical engineering gadget issue topic, and then she started a discussion, what is that really? Yeah, so she had a sketch and a description, but the question was, what is that thing doing, and why is that important? Yeah. So to a certain extent, why do you want a patent for it? Yeah. And then over the discussion, it turned out that the whole thing is about a supply chain issue, and that it is constructed in that way, and it has a certain role in the supply chain for that machine. And then in the discussion, it turned out that what they originally thought, let's say, not what was invented, but which kind of patent they would like to have, what they thought which should be in the corner of in the focus of the invention, is absolutely not the point. It is something different, which is also a part of the invention. But when you look at it from that perspective, a forbidden right later on would really make the job for them to get the exclusivity they really need. But it has nothing to do with the invention per se. You could look at that and that, the different perspectives on it. The reason came from the business intention, and which lied in the supply chain. And that is, I think, that is such a brilliant example that when you don't understand the economic management business context of the whole thing, you are lost. Yes, you get your patent, yes, you get it granted, but is that really the success measure, the objective which the company originally wanted? And that is, so I just want to say, this experience have all the guys, all the patent attorneys who really want to stand in the shoes of their clients.
Yeah, absolutely. I think that this example is perfect, to discuss around, especially you have a patent now, but basically it's much more important to understand, what is the business objective behind it? What is your business plan? What kind of new product line maybe it's the basis for? That's actually, and that's all only appearing, on the surface when you start to have discussions which are not over only about, what about the prior art and so on. So you just talk about business, and that is something, you can learn part of it, to ask these kind of questions. When you have industry background, actually usually it's in your person. It's actually, when you think about inventions, it will be questions you ask about, which I mentioned earlier as well. You ask different questions. Yeah. And if then let's say the chemical, let's say the stomach level, between the person from the firm and the patent attorney, if they are discussing these kind of things, you would probably, and that happens actually what Felicitas probably described in her example, that actually all of a sudden, on the other side, there was a lot of confidence, and they were discussing and a lot of information. And actually, it's a learning for both sides, basically, not only for the patent attorney, also for the business person, the inventor, or the manager on the client side, because they understand that, giving this additional information enables my consultant, to actually to make my success even bigger than I expected at the beginning.
I have a wonderful other example. I think it's wonderful. Another example from Dennemeyer. So I was with Martin Schweiger on a stage, and we had a panel discussion on AI and digitalization, and how will AI change the work of patent attorneys. And then there was a third guy, and a patent attorney, and I don't want to mention the name, but he came up with the thesis that the hypothesis that that all these business-orientated IP, let me say it in that way, is killing the innovation itself. So, and he came up with an example, said, so a company filed a patent not on a real technology, but on the application of the technology in a use case. Okay, and he made this example of a car, and the car has a camera, and at the end of the day, the use case of them, which was patented and granted, was that you have, together with a patent recognition and your camera inside of the car, you have a system with which you can find lost things, your keys, whatever. You lost them in the car. And he gave that example as in terms of, it is ridiculous. Yeah, it's just a use case. And then I jumped in and said, yeah, but when this use case is something which is absolutely driving the business of a company, and when this use case is valuable for them, and as long as everybody says it is new and inventive, so why we shouldn't file and why we shouldn't go for the patent, because it has obviously a value for the company. And who are we to say what exactly generates the value in a business context? The company should know that, we can help the company to find it out. But at the end of the day, we have to give, as the IP system, we have to give the exclusivity with patent rights to the users of the IP system. And I think that is a wonderful example for the fact that that some patent attorneys have a kind of, quality, a feeling about quality, which they think a patent should fulfill. And they ignore that at the end of the day, the user of the IP system is paying for getting this exclusivity. And when they know how to make money out of it, it is basically first prima facie okay. So, but this is exactly what you say. It needs an understanding of the business needs from the company.
Yeah, and as always, in the industry, the development of products or services is changing. In the good old times, you often, or maybe more in the mechanical area, you also have these nitty-gritty things where you have another function with another piece of hardware that you can actually develop, and where you will draft a patent application for. But now with the digitalization and services and the business plans different, they are selling services, and usually there's a kind of business case maybe behind it, and then it's quite easy, not even by the word business case, to have a bridge, to get an interesting use case. And most of the time such a use case that you can protect today via a patent. That is possible, and there are a lot of what I totally agree that you can that you actually should support the client, and basically it supports his business per se, and not only the little valve or whatever you are developing, and sometimes it's really much broader, than only doing this little one. But okay, and maybe it's much more worth, if you have this development on a machine, to also to think about a use case. What are we actually selling to what is our client selling to other clients? And is there an additional opportunity in there? Yeah, and that is something that you actually, when you just come from the legal perspective, you learned as a patent attorney, you would probably not come to this point. Yeah, and with industry.
Excuse me, but I have to mention an anecdote which happened yesterday to me. So we develop an IP management, an academic program, master program in Hungary, together with the WIPO and my colleague Frank Tietze from Cambridge. We helped the university there to develop the syllabus and all of that things. And we had a discussion about licensing. So, and I said, I would prefer that licensing happens on different areas of this program. So we have licensing as a kind of market-based valuation. So it's an outcome of a negotiation. We can observe prices based on licenses, like standard essential patents, whatever. So that is a good signal to understand economic values when we have that price signal from the market. So that is one role. Another role is what I'm talking with Thomas Gerkens always, these IP, these licensing contracts, and the question, can we make sure that the companies are compliant? Do they have a chance to be compliant with that licensing contract? So this is, from a management perspective, a big issue. And then it is licensing can be used to organize business ecosystems like Microsoft, like Android, and so on. So different perspectives on it, and I would like to have these licensing thinking in all of the different business aspects. And then one of my legal colleagues said, Alex, I don't get your point. A license is a pure legal issue. I mean, hey guy, it's 2025. Yeah, we talk for 25 years now about IP management. So, and we are in the development of an IP management course. And you tell me that? On which planet you're living? So that's what you say when you say we cannot reduce it to a pure legal problem. That typically leads to nowhere.
Yeah, actually, it's the legal perspective. This colleague lawyer brought in with said, okay, a license is a piece of legal paper, so to say, with a lot of articles or paragraphs in that. Yes, we need it at the end. Yeah, no doubt about that. But basically, why did we start to write that license? Yeah, that is actually where does it come from? It is not something that is just growing. We have a piece of paper. No, it's a business plan maybe behind it. That say, okay, we have a patent portfolio, or we have a part of our patent portfolio that we see. When we look on the competitors, where actually they are more and more coming into our direction. And it looks like we need to enforce something, and we don't want to fight everybody, because that's most of the time it's a lot of, get in front of a district court and these kind of stuff. And even if you go internationally, it costs lots of money. Let's start it differently. Let's go and let's find agreements with those companies, and we have an additional, so to say, return on investment here. Not only selling our product, others are doing similar things and selling that, so we earning as well, enabling them, and why not using this business opportunity.
So Ben, that leads me to an issue which I had discussed in November with the president the Norwegian Patent Office. As I was there at the Norwegian Patent Day, and we discussed about innovation and digitalization in the patent system. Okay, and that is it is fascinating. It's for many patent attorneys, it's very easy to talk about innovation in general, inventions in specific, but when it touches their own business, the way how they interact with others, they don't think that digitalization has anything to do with them. Yeah? So they would like to be back in time in 2019. Everything is fine. No corona, no new work, no digitalization, no digital client experience, nothing. Yeah. So just back to the good old world. So most industry representatives with which I talk are very, very happy having the possibility to interact in a digital way, to have a digital client experience, simply because it is faster, easier, cheaper, and at least some patent attorneys are also embrace that kind of work. So you as a law firm, you decided to offer that to clients, these full digital experience and interaction. So what is your experience with that new work as a patent attorney?
Actually, yeah, we decided first, to work digitally on our own. So we don't have any paper in our office. We work from remote places. Yeah, so digital work is actually enabling a lot of things. And my experience also from the industry is, automatization or automated processes, digital processes, helps very lot in working together. However, what you do on paper and then you do it digital, a lot of changes usually happens. And today the industry, they use more and more digital processes, SAP based, project management based, and these kind of tools they have. And it's a challenge for us to integrate, because we like to work digital. So a lot of discussion we have with our clients is about how can we be more efficient, which save time on your side, and not only time, only cost then, and the same on our side. Not forgetting that we still have to be efficient as a patent law firm, but there are a lot of ways. And for me, it is always a very important point, to be flexible in this area. Yeah. Sometimes a patent firm or a patent law firm is lucky because maybe your client is not as digital, let's say in the IP management area. So you can connect, you can actually try to catch him and get on your system. Yeah. So that the process between you and the client, or between the law firm and the client, is completely digital and fine, which is a kind of, customer relation binding thing. But it's also possible on the other side, that, if you have a big firm, like, let's say, like the Volkswagens and SAPs, telecoms of this world, they won't actually just say, yes, we would like to go on your system. And so you have to find different ways, digital. Yeah. So, and that is something we always, from the beginning, when we started as a law firm, tried to be open for, try to automate, try to find via maybe sometimes simple interfaces, SharePoint or whatever, to simplify the digital communication and to reduce a paper, be emails. Yeah, today actually the paper from the last decades today is the email tsunami that actually hits the guys in the industry sometimes, even in the big firms. So that is very important from my side. How can we reduce it? And from my experience, a lot of companies are quite open for that discussion as well. They have their, let's say, they have their restrictions sometimes, but most of the time, even if you start with a little thing, if that is successful, then you can be sure you will find another topic, and then you solve that, and you go for another step, you go for another step. it's very seldom that you actually start with big project. Yeah, usually it's actually little steps that brings client and patent law firm or law firm together.
You know, what I hear often is when we talk about, you know, business development, marketing, all these topics which we try to help our IP experts or IP subject matter experts. I get these connotation that yeah, Alex, this is the future. But what they really say is, don't touch me. Don't do anything with me. I don't want to jump over that digital chasm.
Yeah.
And what I see, especially when it comes to AI, so that these digital separation. So there are these guys who, like Bastian and others, and Sebastian. So they have these wonderful digital footprint. They play that game. They use it to also for business development and everything. And then we have the others who even working on paper and wondering why these digital developments have nothing to do with them. I mean, it's simply they stand outside, and sooner or later somebody will have to pay for it. I mean, the companies don't want to pay for inefficiency, and when there is a more efficient support, so then they will switch, and they don't care sooner or later how the patent was created, how the internal management of the law firm is organized. They simply don't. They want the best output which they can get, and they want it to the cheapest price which is possible. And they, at the end of the day, they want to get meet their objectives and want to be understood in their objectives, and all the rest is simply not relevant anyhow. Yeah? So these leather seats and the thick carpets and whatever to signaling we are the best. No, for me that means you are inefficient.
Yeah, that's true. There's also another aspect to this discussion, because it's not only about, you know, implementing or integrating a new tool, a new digital tool, and everything just runs from automatically from itself. You know, it's very seldom that it's the case, because actually not the tool is solving your solution. It's actually the discussion before that you are discussing about how does this process works, and do we want to keep this process when we are, let's say, turning into the digital decade, so to say. And sometimes processes just disappear, because when you discuss about this, you say, well, we don't need it anymore, and then maybe at the end, yeah. So that is another discussion behind that, and that is something you know, I actually experienced a different project in the industry, you know, the digitalization, and it was very, very important. You know, yes, we can buy that software, no issue with that, but actually, do we really need it? Yeah, because sometimes you realize, for example, a company buys a new IP management tool, yeah, and they did not think about requirements, or let's say in detail, yeah, they have it, they have it, yeah, and then all of a sudden they realize they bought a Mercedes, but actually they just need a Volkswagen, yeah. So it's very important to understand your own requirements, and that's basically when you're discussing about digitalization and you try to adapt processes digitally. First, that you discuss, okay, this process, you know, why do we need it? Yeah, and when we are still confident that is something we need, then we can start to think about, okay, how can we optimize it and maybe automate it.
Yeah, and what at the end counts is that I agree 100%. What at the end counts is the digitalization has nothing to do with technology. It is a question of mindset, and that is something where we have to be careful whether we have the right mindset. So, in your case, I'm absolutely sure that there is the right mindset. Thank you very much, Bernd. I enjoyed it very much. To all the others, enjoy your afternoon, and Bernd and I, we are available in the after show party on LinkedIn. So when you have any questions, we are happy to answer in the chat. Thank you, Bernd, and bye-bye.
Bye.